I'd like to take this opportunity to invite the panel up, and while they're making their way up here, I'd like to recognize the Agri Center for allowing us to have it here. They provided the coffee and drinks. Tulare County Farm Bureau provided the almonds, and Milk Advisory Board provided the cheese. So we want to thank them for contributing. I'd like to invite up Annie AcMoody. Annie is the economist with West United that analyzes these programs for us. Tom Wegner with Land O'Lakes, a good resource economist that works in a state order and a federal order. Bill Van Dam from Alliance of Western Milk Producers, very knowledgeable, been in federal orders also and state. And Erba with CDI. The panel will conduct a question and answer session with Bill, and at the end of their questions, then we'll have the opportunity again to go to the audience. So frame a question that you'd like to ask after we complete this, and I would suggest that if you have anything that comes out of this later on, if you forward that to us, we will try to get something from Bill or whoever you want us to put it to, and then we'll try to make sure that all those get posted on the website, you know, so that's have access to that. So at this point, panel, it's all yours.
I guess ladies first. It's
a good way to do it.
So I'll start with a clarifying question. You talked a lot about pooling, depuooling, and you were saying that producers get the blend price and plants pay the class price. Is a plant required to pay the minimum price if they are not in the pool?
No.
Oh, probably shouldn't.
Yeah.
Go ahead. Can we get another floating microphone? John or Dennis? You
Until we get, he's going to stand up there. Yeah.
Oh, well.
Yeah, until we get there. No, if milk does not qualify as producer milk, minimum prices are not in effect. So again, if milk is depuoled, the order does not guarantee producers a minimum price on that. Processors are free to pay whatever they want.
Bill, good morning. It's good to see you again. And thank you for being here on behalf of California State. Folks in this room have a lot of questions, I think, and this panel itself has got a lot of questions. We have an understanding of our own system, but I think most of us up here, except for this guy, probably don't have a very good understanding of your system. So I'll just ask a basic question to get started with. It has to do with the hearing process. You said in the presentation that a hearing might take 14 months, but you've got 2 hearings right now that are open. How is it possible that it will be open if it's only a 14-month process?
Those hearings were started before the new supplementary rules of practice were implemented. And that's why they're still open. There's interim final decisions out there. I am authorized to say that the department is in receipt of a request to terminate those proceedings, but there's been no. We're in receipt of that. So
any hearing that would be started now would be subject to that approximate 14-month time period?
That's correct. And we just had a hearing in the Mideast. Elvin Holland's here, I know. He testified there, and that was done under the new rules of practice.
Thanks.
I would like to follow up on exactly that one. I participated in some hearings myself, and the hearing involved 3 4-day meetings or 5-day meetings in 3 different places. Yeah. With the structure you have with the administrative law judge there and all the questioning, is it going to be possible to complete a hearing in 120 days?
Obviously, I don't know. I would say this, that's what I mentioned when I spoke about that 120-day requirement. The department is very cognizant of what it takes to get it done. That is a relatively short time given what had happened. And I think if it would depend, in my opinion, I would think it would have to depend on the complexity of the issue. If a more complex issues, the department most likely would implement a pre-hearing workshop, which would speed up the process. It would be incumbent upon the administrative law judge to make sure there's not a lot of repetitive questioning in that. Again, I know you've testified a lot. The hearings don't always go from 9 to 5. There's very likely they could go long days, but the department is going to do, I'm sure USDA will do anything and everything they can to comply with these supplementing rules of practice.
Is there any penalty for not completing a hearing on time?
Not that I'm aware of.
Uh-oh.
But that doesn't mean, again, that is something there may be that I'm not aware of. I'll follow up on that, but I'm not aware of one.
Well, just an interesting background, having participated in them, they can just go on forever. And it feels like forever when you're on the stand.
Well, they are, again, they are very inclusive. And the cross-exam, anybody that's tested, I know I said quite a few people here have testified, the cross-examination is a significant part of the hearing record.
I just like a quick question while we're in the hearing process. You mentioned that there's this rules of practice and all that, but when there's a hearing that pertains to class prices, for example, for a specific order, are the hearings pertaining to just one order at a time, or are nationally, is everybody required to comment on that for a specific order?
You know, that's a very good question. I apologize. I should have mentioned this in my presentation. Every federal milk order has two sections. There is the section of the order that is specific order language for that order, and the other section is 1,000. And the 1,000 section are provisions common to all federal milk orders. Located in that section is the Class 1 price surface and the class formulas. So any hearing regarding anything in 1,000 is a national hearing, which means that, you know, that the logistics of that in 120 days might be problematic, but again, so that means all federal orders are probably going to be testifying in anything that's in 1,000.
Go ahead, Annie. What's in 1,000?
Well, yeah. If you could detail if it was in 1,000, is it just the class prices? 1,000
is the definition of a fluid milk product, definition of plants, defines what plants are, the Class 1 price surface, the administrative assessments, marketing service assessments. The main ones are the fluid milk product definition, the Class 1 price surface, and class prices.
So if Californians, for example, wanted to ask for a change in the price formula, somebody in, say, New York could be commenting on what's being asked?
It would be a national hearing, so all interested parties would have an opportunity, yes.
Thank you.
Morning, Bill.
Hi, Don.
My question gets to the work that has to go on prior to the actual announcement of hearing around the proposal that would be submitted by industry. There's a term you use, disorderly marketing conditions, that's been in discussion. We talk about it here as well. You mentioned the notion that there has to be evidence or description of disorderly marketing conditions. Can you give us some examples of what disorderly marketing conditions are?
I don't mean to dance around that question, but that is a very, you know, disorderly marketing, that is something that the Secretary would have to determine exists. And so for me to say, well, this is or this isn't, you know, I don't feel comfortable answering that, so I apologize.
Can I try one?
Sure.
Just curious, maybe you can nod your head or not nod your head. No, in all seriousness, I mean, is price alignment an issue within disorderly marketing conditions?
When you say price alignment, you mean our price surface in regard to every county having a price, or?
I mean the ongoing price within the state of California relative to adjoining markets.
That's, again, I couldn't speak to that.
This is a little bit like, I'm not trying to be a problem here. I'm just trying to understand.
I would say this.
How do we define disorderly marketing conditions?
And that's something that I would encourage anybody, if you're, you know, as any type of process would go forward, the order formulation branch in DC, those are the people that you need to be talking to on this. And again, the fact that, if, you know, it's one thing to talk about disorderly market conditions within a federal order, but to talk about disorderly market conditions in relation to a state order, I'm not qualified to speak to that. Okay. But certainly the order formulation branch, in terms of what would be considered, those would be the ones you talk to.
Let me just make sure I understand, though. I just want to make clear on this disorderly marketing conditions that one of the standards that the Secretary has to meet is identifying that there's disorderly marketing conditions existed in order for her or for him to suggest, let's go ahead with the federal order process.
That is historically, as I have experienced it, that is true.
And
the disorderly marketing is a driver for regulation.
And that needs to be in the proposal that we submit to USDA.
That's correct. And again, the more detailed rules of practice here are available. And again, it'd be the order formulation branch. Will Francis, could put you in touch. That would be again, the federal milk orders, administrators who administer milk orders that we're responsible for. This other stuff, we have our colleagues in Washington D.C. handle that.
Thanks, Bill.
Bill, in your presentation, you made note that there were some differences among the different federal orders in terms of how they set up their policies, their rules, some of the processes. Can you elaborate about what rules or features are different among the orders and how much flexibility there is to be different from your neighbor or from anybody else in the United States?
Yeah, sure. Yeah, again, because the marketing orders are based on the hearing record, one of the first things that, when orders are promulgated, one of the first things that has to be done is to search what is the marking area. What is the marking area? And then from there, okay, what are the marking conditions in this marking area? Are we looking at a high class 1 use, low class 1 use, that type of thing. So the hearing record is the driver. So in pool plant qualification provisions, those are different among orders. So what percent of a distributing plant must be in class 1? And of that class 1, how much is in the area? That varies by order. In terms of pulling the surplus milk, by virtue of using supply plants or co-manufacturing plants, or permitting those plants to be part of the pool, those provisions on how much the cooperatives or proprietary plants must ship to class 1 plants to qualify those vary by order. Diversion limits, how much milk can be moved to non-pool plants that's not needed by pool plants and still priced and pooled under the order, those vary by order. And those are all a result of testimony in the orders. The market administrators have the ability to adjust some percentages, not the class 1 in area sales percentages, but diversion limits, supply plant qualifications, qualification percentages. There is some leeway for market administrators to do that. In terms of when reports are due, handlers have to file reports on how they used the milk for the previous month. We have to take those reports, process them, price them out accordingly. Those dates are different by order when reports are due. When the uniform price is announced, those differ by order. Payment dates for partial payments, the rate of partial payments, those vary by order. The dates for final payments, those vary by order. The administrative assessment and marketing service assessment, there's a maximum, but the orders can move in between. We've actually, in the Arizona order and the Pacific Northwest order, those administrative expenses have been suspended for September and October, so handlers aren't paying those. So those are things that are different by order.
Thank you.
Bill, there's only one order in the federal order system, this Upper Midwest order, that has anywhere close to the Class 1 utilization California has. That puts us in a spot where there is not a lot of Class 1 to allocate among everybody. And the other problem California has is that we've used the term chronic oversupply. Now, it's not true right now, but if it continues to be true in the future, do those two things comport well with being in a federal order, i.e. low class 1 and a lot of extra milk? Well,
I guess my response would be, whether it be an order or not, would be based on the hearing record. I don't mean to be pounding that, but the fact that, as you point out, if you were looking as a comparable area, it probably would be the Upper Midwest, and they have a federal order. So you have a federal order with historically, they've never had a very, in my understanding, they've never had a very high class 1 utilization up there, which doesn't mean they didn't have disorderly marketing, as determined by the Secretary.
Okay. And that's correct, but the second part of the equation is the one that really interests me, is the fact that we often have extra milk. And then my follow-up question to that would be, will you see a lot of depooling of the very large cheese plants and maybe the powder plants under certain circumstances if we were in a federal order pool?
I don't know. I mean, that's not something Who knows? I don't know. That's so dependent on what, number one, if there was an order, what it would look like, what the price levels are. So I would, and again, I'm not trying to be evasive, but I would only answer to the extent that there are federal orders right now that have depooling.
No, this is true. Oh well, if somebody else can turn.
Yeah, and, and speaking of how the orders be determined, how would the order boundaries be determined? What would that mean if California wanted to be part of an order? Could there be two different orders within the state? Could there be just one? How would that be determined?
I think, certainly again, the beginning of the process is a request for a hearing, and that request would have something in it, I'm assuming, on whether one or two. Well, in general, the order bound, you're looking at, where is the distribution area of the Class 1 sales? Where's the primary milk shed? So, again, is it possible to have, in our part of the world, Arizona is a federal order, just the state of Arizona. But in the Northwest, it's the entire state of Oregon and Washington, little bit of Idaho. Other parts of other federal orders do not necessarily encompass all of a particular state. So the fact that you could have some part of the state that's not a federal order and some part of a federal order, there are some states, I have to look at the map now, but at least under the old orders, there were states that were subject to different federal orders. So could there be, if there was a federal order in California, would it be one or two orders? I don't know. It would depend on what was requested and what the hearing was.
Okay, well, because Southern California probably would tend to have a higher Class 1 utilization, could that mean that if Southern California was a federal order, some of the revenues, if the milk, because that's where the milk is sold that matters, if the milk was to move to Arizona, could some of those revenues be lost to Arizona Dairymen, for example?
Again, because under the federal order, the producers receive the average or blend price. All Class 1 proceeds are distributed throughout the entire market. A lot of it is more dependent on the. We talked earlier about the diversion limits. It's how much Class 1 dollars relative to how much milk is there in total. So a more restrictive order that restricts pooling, you're dividing those dollars by less pounds. You're going to tend to get a higher price. So. Could producers, if California was a federal order, the producers again are going to be qualified by basis on their shipment to pool plants. So you could have producers in New Mexico or Arizona or Nevada or where have you that could be qualified producers under an order if there was one here by virtue of their shipments to pool plants.
Okay. Bill, I want to go back to the proposal submission again. We talked about disorderly marketing. Another piece on that is the idea of explaining and quantifying the expected impacts. I'm curious if you can speak a little bit to that regarding what USDA AMS would do to assist in quantifying and estimating those impacts.
The department is available to provide information, on how particular provisions of the federal orders work. If you're asking me, are we going to do a price study, that'd be something Dana would have to decide. Dana Cole is the Deputy Administrator of Dairy Programs. That's not something that a Market Administrator's office would do without approval from Dana. Would we do a study? That would be Dana's decision. I'm not aware that we've done that in the past.
Well, maybe let me just point out a little bit more. A mock pool, for example, where perhaps you would work jointly with the CDFA, where the CDFA would provide data, you might provide guidance on how a federal order pool would be structured to allow us to get some estimate of blend price impacts, classification impacts, etc. Would that be something that we could reasonably expect or formally ask to help us put together a proposal?
I think that at the end of your question there, yeah, that is something that, again, it would not be something that you would do at the Market Administrator's level. Would it be possible? It certainly is. Can you ask? Yes, that's things you should be inquiring with the order formulation branch and Dana Cole is because you're getting into higher end policy stuff there. And the Market Administrators, we just administer the terms of the order. So that type of policy, again, I'm not trying to dodge it, but I'm not speaking out of turn either. That's not my decision.
Okay. Can I ask another one now? Just curious if you can tell us a little bit about what the most recently adopted federal order was, and if you have staff that have gone through that process. I'm thinking that it's the Carolina order, mid-90s perhaps?
Yeah, I'm trying to think. Certainly in the West, no. So, I mean, one answer to part of that question, no, our staff in Phoenix and Seattle, we don't have any hands-on experience on a new order. That again, my Harold Freely, the market administrator in Louisville, and I did, as a Yankee, I know how to pronounce it. It's not Louisville, it's Louisville. So, but he would be the one to go to, because I believe you're probably, I'm trying to think, obviously some new orders were created through order reform, but that was informal rulemaking. So in terms of from a formal rulemaking process, you know, that you may very well be right.
Okay, thank you.
Bill, I spent a lot of time putting together some questions that I want to ask you, and you keep adding stuff that I got more questions on.
Well, that's my fault. I'm trying not to.
Several hours trying to get through all this material. There is an expectation, I think, that if California would go to a federal order, California state would be the order. And you mentioned something about determining the boundaries of the order. Is it possible the Secretary could look at the hearing record, notice I said look at the hearing record, and suggest that Southern California and Arizona belong together as an order, and Northern California is its own separate order?
You know, again, as you point, I think the Secretary would any decision the Secretary would base, excuse me, he or she would do, would be based on the hearing record. And so there would be testimony in that hearing record that would either indicate to the Secretary, yes, it should be separate, yes, it should be together. It would have to be in there, and it would be as a result of probably some extensive testifying and cross-examination of it.
Thank you.
Eric, just for clarification though, Bill, that would be something that would be in a proposal. It wouldn't be such a thing where the Secretary would look at the record and come up with a new idea about where the boundary should be. California would come in with that proposal, or the industry would come in with that proposal.
Again, there are times where there is an initial proposal, and those proposals are modified during the hearing process. But I would tend to, I don't know why I would disagree with that. That you have an addition, if the initial and only proposal would be for A, and then all of a sudden the Secretary's not going to say, no, we're not going to give you A, we'll give you something else, when that was not proposed.
Okay, that's really true. Thanks.
But the odds of this being, if we were to have a hearing for California, the odds would be that it wouldn't just be Californians testifying. There'd be people from all over the country testifying on how to set this up. So even if you went with a proposal, wouldn't there be a myriad of other proposals being made during the hearing? This is a logic question.
No, and again, I'm not trying to be evasive, but I fall back on the rules of practice is that the Secretary has the opportunity to request additional proposals when a proposal has been received. And again, the fact that interested parties, which means anybody can testify, I would agree with you, yes. There'd probably be quite a few people testifying, but you know, maybe not. I know it's hypothetical, but it's an open, inclusive process.
Okay. Yeah, and it'd be one of fairly great interest to the rest of the country, I believe. Another thought that I have on this thing, I saw your comments on your slide about the federal order, people can collaborate with states. Is that a broad enough statement there to somehow or another deal with the quota issue that exists in California, the existing quota?
No, and I mean this sincerely, not being a lawyer, that's really is a sub-question that probably OGC, which is Office of General Counsel, that's the government lawyer, that's really something way beyond me.
And I appreciate that answer because I believe that is the question. It's such an intricate legal question that everybody has to keep in mind here in California. If we're going to move to a federal order, what are we going to do about quota? Can it exist within the system? There's some belief that it can be, but not necessarily true.
Yeah, just to follow up on quota, because you did mention on your slide the authority for Class 1 base plans was terminated. That was a little bit different than quota. So if California, for example, wanted to allow quota, they'd probably have to go through legislature or...
As I think most people probably know, during order reform, there was a regulatory window where California could come in with the quota plan as it existed. That authority has expired. But yeah, the act as it currently is written does not permit any type of plan that's tied to Class 1 use, or Class 1 base plan.
list there.
There's a lot to choose from there, Bill. I'm sorry. Maybe I should throw you a big fat curveball right now that you're lulled into a sleepiness state here. Ask you a question you're probably not going to give a very good answer for, but I'm going to ask this question anyway. Does USDA have a desire or no desire to have California be part of the federal system?
That's a no-brainer. I can't speak to that. I have no.
At least I told you the curveball.
That was, yeah, well, you know, I can't even hit a fastball, but no, I have no response to that.
Here's another one for no reaction. I've heard this relatively recently, that if California would be part of the federal system, then the federal system could move toward what California was or is, or however you want to say that. Have you heard anything like that, and do you have a reaction to that, and how possible is that to happen?
Yeah, you know, again, I'm authorized here to speak about how federal orders work, and not authorized, you know, or pay grade or food chain anywhere like that. But again, these are the type of issues that need to be taken above the market administrator level. These need to be discussed with the people in our staff in Washington, D.C. that are closer to the policy makers in OGC. So I encourage, if you haven't already, to go that way.
Thank you. Bill, as you know, I spent some time with dairy programs so know a little bit about some of the, again, getting back to this proposal portion, because I think that's very, very critical for us as an industry in California, is if we're going forward with this, to understand what the proposal submission process is and what needs to be contained. Something that's not written here that I would hear when proposals would come into Washington, this is getting on 30 years ago actually, that the industry was asked, are the cooperatives aligned? Are the cooperatives in agreement behind the proposal? Now, is that something that the Secretary and Dana Cole out of AMS Dairy Programs would be interested in, to know where the cooperatives are, where the proponents are?
You know, I would just say this, that, you know, these are producer programs, and so producers have input in terms of the question you're asking. You know, that's something you'd have to ask Dana directly. And again, I'm not trying to duck it, but I'm not going to speak out of turn for something that's not in my elements and standards. So no, again, that we are producer programs, so certainly the input from producers has to be there.
Okay. Let me try one more on this end, if I may. I'm curious if you could tell us a little bit about why you thought the Western Federal Order was voted out.
Well, there's people here that voted, they might say, but I would say this, that we conducted an extensive hearing, we published a recommended decision, we received comments on that recommended decision, we published a final decision, and the producers voted no. One of the proposals at that hearing was for market-wide service payments. The Secretary did not put that in there. Other provisions, pass-through provisions, net shipment provisions, eliminating the bulk tank handling provision, those were all in there. So I don't know why people voted no. But I know it was, the process was, the integrity of the process was protected because it was a lengthy hearing.
Yes, that was a lengthy hearing. I participated. I didn't testify, but I was at all the hearings, and many of them went way into the evening. And boy, you want to get rum-dum, go to one of those. On the vote, I want to make sure I understand the vote, and everybody else does too. You said it has to be 2/3 vote, yes, but if there are not 2/3 yes votes, and there were just more than 1/3 no votes, it's over.
That's
Vote
right.
it out.
Either 2/3 of producers or 2/3 of milk. If you don't get either one of those, then done.
And then the entire order is done, and that's what happened in the Western Order.
That's correct.
And by the way, you mentioned the main point of contention in that why it got voted out. Thank you. Oh, I'm sorry, Annie.
That's all right, you make me wish that I'd been to hearing. That's makes it sound very exciting.
Well, if you get paid, you might go.
Thanks. So just to get back on pooling a little bit, just because producer pricing is something that I look at on a daily basis. And so I was wondering, what happens, you say producers have to qualify in order to be pooled. Does it happen that producers would want to qualify in order to say that has lower classroom usage and they can't qualify? Like, is it something that is a possibility?
Certainly, if a producer, again, if the producer can't meet the qualification provisions, then they can't be a producer. You can be a producer under more than one federal order, but not for the same milk. So we do have orders in other parts of the country. You know, we're fairly isolated here in the West, but in areas of the country where the orders boundaries buttress each other more, there's lots of producers that have their milk pooled on multiple orders, but that means they meet the qualification standards.
Bill, could I follow that up with a question about plants? Can a plant be pooled in two separate orders?
No.
So they have to choose the one they're most prevalent in, and that's the one that...
Well, you are, if you qualify under more than one, say there's two orders that are, say they're both 25-25. So you have a fluid distributing plant that it's 25% under both, it's 25% class 1, and then under more than one order it has 20, say it has 25% in Arizona and 25% in Texas. We're going to look to the area where the majority of the sales are. But you're not going to be regulated in more than one order, just one.
Okay. And going back to the Western order, when we touched on that, and I meant to make this point before, but on the Western order, it was another one of those orders with a very, very low class 1 utilization. And that is part of the reason why the enthusiasm for staying in it wasn't great, because the benefits were so small that were being distributed across. That's just background information instead of a question. But do you agree, Bill? That's a question, wasn't it?
It was a nice effort to make a question. Are you going to respond to his question?
I bow to his expertise.
Bill, every month we've got some milk that comes into California, either in bulk form or packaged form. If you go to a federal order, is that likely to change the movement of that milk across the state line?
I don't know that, but the fact that, again, one of the slides, the fact that the federal order is a regulator of state commerce, if packaged milk moves into a federal order that's not priced under another federal order, then that milk becomes, if a plant sells milk into a federal order and that plant is not regulated under another federal order or that order that's selling it, then that plant could be partially regulated. So if package sales, say, would come into Arizona from a plant in Idaho, what have you, and first we're going to look at, okay, is this plant 25% class 1, or are we getting 25% of their sales? If we are, it's a pool plant. If it's not, but has package class 1 sales in our area, then that plant is partially regulated. They have several options to pay on, so they're going to have to pay a compensatory, or they may have a compensatory payment into the pool to try to equate class 1 costs among handlers and keep the class 1 price structure whole. So they can pay the difference between 1 and blend at location. Again, the fact that producers always get the blend price, handlers' value is always the class price. So in this case, the class 1 and blend, this is the Lehigh Valley decision, which is one of the famous decisions, was resulted in the class 1 blend price. So compensatory payment, difference between 1 and blend, that class 1 handler would pay that into the pool, so the class 1 sales integrity of the order is protected. Or that plant could pay for its milk supply at least the equivalent of what it would pay had it been fully regulated. So again, we would get a report from that plant, we would compute its utilization value, we would determine what they would pay, again at class prices. If they were fully regulated, they would provide us, and we would audit information on what they paid for their milk supply. If they paid at least that much, there'd be no compensatory payment. So I think in general, yes, there is the federal orders have a way to protect the order from outside sales. In terms of bulk milk coming in, again, if it's from a farm, then we're going to look to see if that farm qualifies as a producer. If it's not a producer, it's dairy farm for other farmers' milk, it's down allocated 4321. If it comes by transfer, then it's received from an unregulated supply plant. So now we're going to look, okay, does this guy qualify as a supply plant? And if not, then it's unregulated supply plant milk, and again, allocated 4321. And if it gets into one, there's a compensatory payment.
Right. That was one of my questions, what's compensatory payments, so I can cross that one off my list.
Ah, hey, I'm ahead for that.
Excellent. Another question for you. We've got a number of large producer distributors in California, and you've got very specific ways of handling PDs outside of California that really don't mesh well with how we regulate those entities now. How would that work in a, let's say we go to a federal order hearing, what are you going to do with those PDs in California that already exist as PDs? They're not going to mesh well with the regulation you've got out there right now for federal orders.
Right. The federal orders as a result of the hearing process. First hearings involved actually our orders, the Arizona order, Pacific Northwest order, and regulated producer handlers at a size of 3 million pounds of Class 1 sales in the area. That is now a provision that's common among all federal orders. So what we call producer handlers, otherwise known as producer distributors, another part, if they have 3 million pounds of Class 1 sales in the area, they would be fully regulated, which means all their milk would be priced. If they have less than that, then they're going to be partially regulated if they're over 150,000.
So there probably be no grandfathering in of these PDs in California?
That would be something that the second, is that possible? I don't know, but the way all the orders are currently administered, that there was no grandfathering when we put it in.
Great, thanks.
Going back again to the proposal prior to hearing, as I understand, we have these number of different items that we need to put in: disorderly marketing conditions, description, purpose, cost impacts, etc. Cost impacts small businesses, etc. You received this proposal. At what point does the department go into the ex parte mode, and no longer can we seek counsel, can we seek technical advice? Can you say a little bit about that timeline?
When the notice of hearing is issued.
Okay.
So up until the time the notice of hearing is issued, and I believe this is the same in a lot of regulatory programs, up until the time notice of hearing issues, we can talk. Once a notice of hearing is issued, then we're prohibited from talking about the merits of the proposal. So yeah, at the time the hearing is issued.
And the USDA has 30 days after receiving the proposal to make a decision about when the hearing notice?
Well, they would announce an action plan, and that action plan may or may not include a notice of hearing. This is not something I work with on a day-to-day basis, so in terms of days, times, I don't know, but I do know that the ex parte kicks in at the time of the notice of hearing.
Okay, thank you.
And again, we only have one hearing under the new, we don't have a lot of experience ourselves under the new procedures.
Bill, this might be outside of your expertise too. It's a neighboring order to you over in the western Texas area, New Mexico area. But as I look over their pooling records, first of all, what I notice is that the pay price in New Mexico is very similar to the overbase price in California. Well, not overbase, over to the California calculated average mailbox price. They're very similar to each other. Yet they are in a federal order. They do have a high volume of class 3 and 4 milk. I don't know how big their 4 is, but I know the 3 is substantial. And what you've got there, if I look at these numbers right, only about 39% of the milk is pooled. And that means the other 60% is not pooled. Can you comment on that, and whether that, I'm trying to get at that same question again, what happens in California if you do have an order when you've got somewhat similar circumstances? In other words, a lot of milk and sometimes excess.
Again, I have little or no knowledge, day-to-day knowledge of Order 126, which is the order you're speaking to. So, number one, I would suggest you call Kerry Hunter, the market administrator there. But I would say this: I heard you say the mailbox price. We're looking at, the federal orders announce a uniform blend price. The mailbox price is something different. So, and in terms of, and when you're saying the 39%, I assume you're probably looking at NAS state production numbers and looking at the milk that's being pooled and looking at variance.
Yeah.
Again, not being intimately aware with the market dynamics in that order, but that milk may be moving east. I don't know.
That's possible. Another general question: if the milk moves east from Texas to Florida, does that reflect as Class 1 milk sales in the Southwest order?
No, the milk is going to be pooled under the order where it's a pool plant. So if milk were to move from, say, East Texas, New Mexico, or East New Mexico, and move for, I don't think it's a big secret that the Southeast is a deficit markets. You know, they need milk. So if milk has to come from somewhere. It comes from, up in Ohio, Indiana, or move over. And these are the type, Market Administrator's offices, we publish production by county figures, and production by state. So you can see the milk that's being pooled, where that's coming from. So you probably look there on the websites for order 5, 6, 7, and see where that milk's coming from. But again, it would only be reflected back to say Texas in this case, if it was transferred. If it's diverted, then again, it can be diverted for 4, 3, or 2. But if you divert milk to another federal order, if any of that milk by the allocation process, if any of that milk adds up in Class 1, that Class 1 is producing milk under the order that it's in. That Class 1 dollars do not come back. 2, 3, or 4 can.
Thank you.
Yeah, and just to follow up on that, then does that mean that a producer, for example, shipping to a plant in Tulare could be getting a different price than a producer shipping to a plant in LA County, for example?
Right. Under the federal order price structure, every county is county-specific pricing. Every county has a differential, and the uniform prices are announced at a base zone. And so if you deliver to a plant, and milk is priced at the plant of first receipt, so producer's blend price is calculated accordingly. So if they say the order is the blend price is $1 at the base zone, and you deliver to a plant where the location adjustment is $1.10, you're going to get the base zone price plus 10 cents. If you deliver to a plant that say it's 90 cents, you're going to get the base zone minus a dime. So the producers are going to be paid, again, milk is priced on the basis of plant of first receipt, and the producer's blend price, when they go to multiple plants or a single plant, is going to be based on the value of the milk at that plant.
Okay, and I'm assuming those differentials are based on market conditions?
They were implemented in order reform in 2000. And again, that's something that's in section 1000.
Okay, and that's not, so basically hasn't been updated in 12 years.
That's correct. And off the top of my head, again, there's a differential for every county in the country, so there's differentials for California. I believe the low is $1.60, which is the lowest it can go in this part of the state where we're at right now. It goes up to $2.10 in Southern California. And I believe in Northern California, it tops out at something a little bit less than that, maybe like $1.80 to $2, something like that. That's, again, off the top of my head. Okay,
and if California wanted to change those differentials, for example, would that have to be part of that Section 1000 you mentioned earlier, like a national hearing?
In my opinion, yes. I don't know how it couldn't be. Because, again, the price surface is a national surface. It's looking at how things relate to nationally, not just locally. So, but again, that would be a question I really can't give you a definitive answer.
You mentioned the location differentials, and I have a different kind of a question. Have you, in your experience, have the location differentials that have been established 12 years ago, are they sufficiently large enough to get milk to move to deficit regions, or are other over-order mechanisms needed to get milk to move?
Again, I think that I would say we all know the M's, right? Money moves milk, more money moves more milk, much more money moves much more milk. If their handlers are free to pay values above the minimums, if that's what it takes to move milk. And the orders, that's not something the administration of the order would deal with. That would be more a supplier-buyer relationship. And people in here that are doing that for a day-to-day basis, they could answer that much better than me.
Okay.
Well, I think I've got one more. This one has to do with quota again. As I understand, the state of Oregon had a quota in place prior to the federal order becoming adopted in Oregon. Can you offer any insights into that process, into that history?
I can offer anybody a copy of it. You know, again, our office has, this is the final rule that implemented a plan in the state of Oregon. And as I read this, my interpretation is that it was a voluntary program in the state. And what the federal order did was, there were producers. Again, this is an official document. This is our final rule, again from 1969, Federal Register. Anybody wants a copy, just let me know. But the way I read this and looking back at some of the other hearing stuff, Oregon State had a voluntary Class 1 base plan that not everybody in the state participated in. And when a federal order came in there, it recognized that. So you had a situation where you had producers that were in Oregon that weren't part of that state Class 1 base program. You had some that were. You had producers outside the state that were not. And so how that worked, all the handlers all paid their use value. So their classified use value, how they used their milk times the class prices, they paid that money to the, obviously we computed the blend price, but all that money came to the market administrator. The market administrator then paid producers who were not participating in the state of Oregon plan the federal order blend price applicable to their milk. For producers who were part of the Oregon state plan, the federal order turned over the blend value and aggregate for all that milk, and that was redistributed by the state. Now, Bill, do you have any first-hand knowledge of how that worked or not?
No, my knowledge is real close to firsthand, but it's not, because that was done when I got there and started participating in Oregon. But I do remember what happened is the internal friction between the two areas, Washington State and Oregon, and in the presence of the federal order. And finally, they just threw their hands in the air and they said, this simply cannot continue to exist within the federal order. And the primary reason for it is that the mentality of the federal orders, it's been consistent over time, is based on the sharing of all the usages across all producers with no favoritism. That's deep within their DNA. They feel strongly about that. I've noticed it in other hearing findings. You can find the sentences that make that clear to you. And they just weren't willing to participate in the longer run with sharing it. I think they would have kept it going if the producers were happier, but the producers were not happy. People readily moved milk from Washington into Oregon to water down the pool. It just got real strange and goofy. Anyway, that's not a very scientific answer, but that's what happened.
Bill, you mentioned in your presentation the PPD, producer price differential. I wonder if you might take a moment to explain what that is, how it works, and if all orders must have it or do have it.
Yes, the producer, as I pointed out, there's 6 orders that have component pricing on manufacturing milk and 4 orders that do not. The 4 orders that do not, of which Arizona is one, we announce a blend price. We have a skim value for that and a fat value for that. So producers are paid on their pounds of fat times uniform fat value allocation and accordingly for skim. In component orders, producers are paid the Class 3 price. So the Class 3 price has a protein value, another solids value, and a butterfat value. And so if the value in the pool, so basically producers right at the top of the go on a component order get the Class 3 price. So if the total value in the pool is equal to the total value of Class 3 milk, the PPD is 0. If the total value in the pool is something less than Class 3, you have a negative PPD because there's not enough money in there. If the total value in the pool under ideal circumstances exceeds the total value of Class 3, then you have a positive PPD. So it's a function of the value of the pool as it relates to the Class 3 price.
Thank you.
For my history with knowledge of federal orders, I have never seen any discussion about the Class 3, whether it was containing all manufacturing milk or now Class 3 and Class 4, was anything but a national price. Always a national price as compared to Class 1, certainly. In order reform, are you aware of any discussions where, or research regarding the Class 3 price, Class 4 price, having a location element to it?
You know how far yesterday seems. Now we're talking 12 years. I think prior to order reform, we did have a 3A price. We had 3 and 3A. And as I recall back, prior to breaking out butter and powder and cheese and separate, so the federal orders now, cheese is Class 3, butter powder is Class 4. Prior to that, butter, powder, and cheese were all in the same class, Class 3. And as I recall, and I believe in the early to mid-90s, there was some concern about the disparity between cheese and powder. And so we had 3A pricing, so that was a regional manufacturing price. But since order reform or during order reform, as far as regional prices, I would have to go back, and this is available if people want a copy, I'd have to go back and read the final decision where we discussed, because we had, in the informal rulemaking, there was a lot of information that we went through, and so I'd have to go back and read the final decision to see if there was any discussion, because we were looking to find a BFP replacement. That was still the basic formula price back then, which came after the MW Minnesota-Wisconsin series. So I'm not ringing a bell, but there may be some discussion in there in terms of what was talked about as a replacement for the basic formula price.
Thank you.
Just I'd like to touch on that same point ever so tiny little bit there. I believe it's 90s, might be the 80s, sometime in there. There was a situation where they were arguing for a lower, especially Washington State in particular. They got themselves a very difficult spot, distance from the market and stuff. And they talked about and noodled their way through some kind of alternate price for milk that's made into butter powder. But the federal order came back and said, okay, we're going to change the support price also to reflect that same difference. And when that applied, then the producers in Washington didn't want to have any part of it. So they shot themselves in the foot on that one, depending on how you look at this. But that's a little piece of history from way back.
And I think it was probably the department that changed the support price, because that order doesn't, it'll be the department, or the USDA or secretary, whatever, decided to make some changes.
I have no other questions.
Bill, thanks for clearing that up for us.
Just like mud.